it's just that, at this meeting, it comes out that Jeffrey Williams is with Mr. Donovan Thomas days before he's killed, according to Mr. Sledge. I have other evidence that puts them together, but that's the contested part. It's not really Rich Homie Quan, it's Mr. Thomas, Donovan Thomas. And what the state's trying to say is that, for the court's edification, I believe this is what they're saying, Mr. Thomas is trying to be the manager of Rich Homie Quan. Mr. Thomas doesn't want Rich Homie Quan to sign with a man named Mr. Brian Williams, who's Birdman. Jeffrey Williams is not signed with Brian Williams, Birdman. And somehow Jeffrey Williams doesn't like the fact that Donovan Thomas won't let Rich Homie Quan sign with an independent person. Mm-hmm. So Jeffrey Williams has him killed. The jurors may adopt that. But when Mr. Sledge tells District Attorney Love on June 9, 2024, that Jeffrey Williams and Donovan Thomas were outside, and I thought it was TIG, but T.I.'s studio. He's a performer he's a wonderful performer named Clifford Harris in Atlanta. Mm-hmm. And they're having a good time. That's Brady evidence. And I never got that. Now I did get, I don't want to, there's no violation. I'm making it clear. I got it from Mr. Sledge and Mr. Wright. But we should have gotten it from the DA as well, because they didn't know, I assume. They didn't know that I got it from other people, and I don't think Mr. Matthews got it. I didn't share it with him anyway, so that's Brady evidence for him too, because it's part of the state's case. Those are my issues. It just, that's one witness last week, and it's the objection, it's the Brady, and it's the reading of a transcript. It's just a lot to deal with, and that's it. My objection, I asked for a mistrial. I'm God willing honest with everyone, but I don't want a mistrial, but I don't know what to do. So those are my issues.
All right, thank you.
And I do apologize for misspeaking, and hopefully I cleared it up.
I mean, it happens. I don't find any purposeful action on your part in saying the wrong year. But
thank you, Your Honor, for allowing me the opportunity to speak. I apologize to the court in advance. My voice is a little lacking today, but as we are bringing up things and patterns, I want to bring to the court's attention a couple of things that the court would not have knowledge of, as the court could not have been present when it occurred. I've read the portion of the transcript where I said, as it relates to a young man in the picture, I believe evidence has come out that, and I want to read it exactly as I said it.
Well, I mean, I already read it out once.
Mr. Steele was putting up is a picture of defendant Williams with a young man whom evidence has come out did not associate with defendant Williams after a particular time. So there have been instances during this trial with other witnesses, much like the way that Mr. Steele is alluding to instances that the state has brought up. I'm bringing this up for a reason, if the court would give me an indulgence, where the state has asked a witness a question. For instance, did Mr. Steele ask you to, did Mr. Steele stop the recording while you were talking? And Mr. Steele literally verbally stood up and said, that didn't happen. That did not happen. See right there. And so giving testimony during trial, I did make an objection to that. That was addressed. That, in my estimation, is wholly different, and that is the kind of thing that it would appear Mr. Steele is sort of alluding to the state having done now, and it's not. I did not state anything about the weight of the evidence. I said vaguely as I could, I believe this has come out. The jury will know. My objection was intended to inform the court as to why I made that objection. I will point the court's attention, since Mr. Steele has brought up these interviews he's talking about, to the discovery we did provide.
You know what? He admits there's not a violation. So have you found the portion of the transcript that you say supports your assertion that evidence has come out that whatever?
Since I didn't name a person,
I understand, but then you said to me
I did.
afterwards, outside the presence of the jury, I've got a basis for saying that.
And I did.
Okay.
During the examination of Donovan Thomas Sr. by Miss Hilton, she asked whether or not Mr. Thomas Sr. ever saw this person, this gentleman that I was referring to, and Defendant Williams perform again after December 2014.
Okay.
He said no. That was the evidence. That is the reason that I said that evidence has come out that these people didn't associate after a particular time. I intentionally did not want to speak on 2015, 2014, but I can state in my place that unlike interviews and all of that, we've had interviews by people other than counsel in the courtroom. We've actually had interviews where we have had investigators told that after the murder of Donovan Thomas, that this gentleman and Defendant Williams did not speak again, period. After they saw each other in Miami following the murder of Donovan Thomas Jr., a question was asked, where is Woody? Defendant Williams told this person, Woody was in Atlanta. This person looked over and saw Woody on a turntable or something in that same club, and this person walked away and did not say another word to him afterwards. The point that I'm making is that when I see an assertion by counsel that there has been something, a concert by the two of them in December 2015, and the statement wasn't made, it's a leading question, so it's essentially a statement wasn't made once, it was made more than once. And then the witness adopted it and said, yeah, it was in 2015.
All right, so
don't know
I think
any other
I
way to
see the
correct
portion of the transcript that you might be referencing. It is on page 45 of the rough of Mr. Donovan Thomas Sr.'s testimony. There's a question about a video shoot in Birdman. After this video shoot, to your knowledge, did your son ever promote anything dealing with Jeffrey Williams? The answer, after the Fulton Industrial video shoot, no. Is that what you're talking about? Or is it something else? Because it would be nice if y'all could point me to the part of the transcript. But you know what? Regardless, I think that the issue and the reason that Mr. Steele made the motion is because you said in front of the jury, and I hear you saying Mr. Steele did the same thing, which honestly, y'all, neither of you, that if it is improper, the fact that the other person is doing it doesn't make it less improper. Two wrongs don't make a right. Y'all are familiar with that. But I understand that you were trying to correct the misstatement about the date and essentially say, you know, it's not possible. The better way to have done that would probably have been to say, can we approach and call to Mr. Steele and the court's attention why it is that what he was saying about 2015 wasn't possible. So I don't think that it is anything that is serious enough to warrant a mistrial. But for both of y'all, for everybody, if something like that comes out and you think for whatever reason that something is getting misstated by the attorney, just ask to approach and we'll deal with it up at the bench, okay?
Your Honor, there is a...
Can I get everybody's okay on that?
Absolutely.
All right, great. Go ahead.
Thank you. There is an issue that I have experienced. I have made an objection, and when I hear an objection, if the objection is made to my question, I pause.
Yeah.
But that does not happen. And so if when I object, a person continues to talk and improper information is being put before the jury, I don't know what else to do
Okay.
if that.
I'll address that. So I noticed that as well. Everybody, when you hear the word objection, stop talking and let me hear what the objection is. And then sometimes I will still need to hear the entirety of the question because I won't know whether the objection is meritorious or not because I'll need to hear the rest of the question. But not always. So just stop what you're saying. Let me hear the objection. And then if I need you to tell me the whole rest of the question or whatever it was you were saying, I will let you know that. And then you can, and then I'll make a ruling. Can we operate like that from now on as well? Great. Okay.
May I approach Mr. Sledge?
You may.
Mr. Sledge, may I approach you?
Yes, sir.
I'm showing you what I've marked as Mr. Williams or JW 255. Would you take a peek at this for me? Tell me whether you recognize that item.
Yes.
And is it in the same condition? Have you seen it prior to, 2024, 2023, going back? Is it the same condition?
Yes.
Any alterations or changes to it that you can tell?
No, not allowed to see.
Your Honor, I move for the admission of Mr. Williams 255.
It's admitted.
May Mr. Kokomo display it, Your Honor?
Yes.
It should come up on your screen, but it should be the same exact thing. You could check it. That's in front of you, okay?
Yes.
And if Mr. Kokomo can blow that up at all, and if not, that's fine. So this is exhibit number at the very top, Mr. Kokomo, if you just show. You see where it says exhibit or EXH number JW, Jeffrey Williams 253? I believe it's 255, though. Let me see if I can. All right, you see at the very top 255?
Yes.
Okay. And then if Mr. Kokomo can just center so all the words can be seen on the actual writing. Do you recognize this as a social media posting? And do you see the date?
Yes.
And it's from DMAC, got me to TOO, banging at DMAC to banging. You see it says December 27, 2014.
Yes.
And does it read then, and I'm changing it just because that's how I am, A-N, lie to their mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, 3 question marks. I don't get it. And then hyphen at Young Thug. Do you see that?
Yes.
All right, did I read that fairly accurate? I know it wasn't perfectly accurate, but fairly accurate?
Yes.
All right. And is that similar to what has been marked and played in states number 447Y, where you started out with, I'm going to, and this may not be exact quote, but something like, I'm going to swear to tell the truth, I'm going to lie on God. You remember that?
Yes.
All right. Can you tell the jurors what it means, if you know, when it says at the end of it, the hyphen at Young Thug?
Before it,
Can
I
you,
don't.
can you explain that to the jury?
I don't get it.
Yeah, right after that.
At Young Thug Thug. I mean Young Thug. I'm sorry.
Yes, do you see that?
Yes.
Do you know, and if you don't know, just say, I'm not sure. Do you know what that means?
No, I don't
That's
know
fine.
exactly what it means.
Okay, and this one goes back, if you remember, if you don't, we can show it to you. But do you remember what the state used on January 26, 2015, said repost? You remember that?
The repost whiz.
Yes.
Yes.
Okay, and then you showed the jury the January 4th, 2015 video, same video, Jeffrey Williams, you remember that?
Yes.
And this one is approximately a week before January 4th, 2015, right?
Yes.
December 27, 2014.
Yes.
And prior to this, prior to 2014 and 2013, 12 going back, have you heard the same type of statement?
Yes.
Okay. All right. Now, did anyone from the police department or the district attorney's office, and I'm saying after you entered a plea, so this is December 28th, 2022, okay?
Yes.
After that, so coming forward.
Yes.
Did anyone from the district attorney's office or one of their teammates, police, whomever, did they ever ask you?
Objection. Relevance as to what anyone else ever asked this witness. If Mr. Steele wants to ask something, he can.
What's the relevance?
Ask about the evidence of the reposting? They showed the gentleman the evidence?
Your Honor, my
Know if
objection.
I want to know if anybody ever went over with him that it's a repost?
Your Honor,
Sustained.
Did, at your meeting, we'll just do it on June 9th, 2024, at the Fayetteville Starbucks?
Yes.
Did District Attorney Love ever ask
Objection.
you about,
objection.
objection.
Yes.
Sustained.
did State's Exhibit number 447Y, the repost, January 26, 2015, was that ever discussed with you?
Objection, Your Honor.
Sustained.
All right. Where it says on the January 4th, 2015 video, and if you need to see it, I'll show it to you. Do you know what I'm talking about?
Yes.
Okay. Where you read to the jurors that Mr. Martinez or Duke said it first?
Yes.
Remember that? Okay. Did you ever explain to anyone about Mr.
Objection,
Martinez
Your Honor.
saying it
That would be
first?
hearsay.
He's right here.
Explaining outside the court, it would be relevance and objection.
Sustained.
All right. Now, District Attorney Love asked you on your direct examination why you didn't go to the police on the morning of January 11, 2015, when you dropped off Mr. Copeland at the City of Atlanta Police Department homicide. Do you remember that question?
Yes.
All right. And you were aware that the police called Mr. Copeland
Yes.
that night, and then Mr. Copeland went down to see the police, right?
Yes.
Did the police call you and tell you that you were the prime suspect?
No.
Objection to the compound question.
Overruled.
No.
You were asked questions about the music company or business YSL, direct deposits. You remember that, working for them,
Yes.
working for Mr. Williams? You remember all those questions?
Yes.
All right. Do you personally know, do you personally observe, does that music business have lawyers working for them? If you know. If you don't know, just say I don't know.
I don't know.
All right. Do they have accountants?
Yes, I think they have accountants though. I know that.
How about managers?
Yes.
Objection, Your Honor, vague as to managers.
Overruled.
Yes.
Now, you were asked a lot of questions also about what you explained to the jury, that anybody can claim YSL. Do you remember all those questions?
Yes.
There was no beating in, there was no initiation fee. Remember those type of issues?
No. Never have that. You never have to get beat in or however.
Somebody could just say, I'm with YSL.
Right.
By doing that, does that mean that they're with the record company YSL?
Objection, vague. By doing that, I don't know what the.
Overruled.
Now, you mentioned yesterday meeting with Jeffrey and Mr. Brian Birdman Williams and yourself and Mr. Donovan Thomas and others, I'm not excluding others, shortly before, God forbid, Mr. Thomas was, days before he was killed on January 10, 2015 at TI Studios. You remember that testimony?
Yes.
Is TI the performer TI that you're talking about?
Yes.
Do you know his real name?
Something Harris. That's how I know. I know his last name Harris.
Mr. Harris?
Yes.
And is he a phenomenal, well-known, accomplished artist?
Objection, Your Honor.
Sustained.
You were asked about the definition of snitching. Do you remember that?
I don't remember asking me that.
All right. Do you remember saying in the video 447Y snitching, and I'm not going to say, but BIT blank 8?
Yes.
Okay. And tell the jury what snitching means.
To me, my definition of snitching is another person lying on another person.
Now, on from December 28, 2022, I'm using that date because that's the date that you were released from custody on this case. That's the date of your guilty plea, okay?
Yes.
All the way through today, but including Sunday, June 9th, 2024, when you met at the Fayetteville Starbucks,
Yes.
the district attorney and your lawyer and the investigator. Did anybody go over with you what's been gone over with you in court, the plea agreement?
No.
You told the jury that Jeffrey idolized or idolizes Lil Wayne or Mr. Dwayne Carter. Do you remember that testimony?
Yes.
Did you ever hear, are you familiar with Lil Wayne's work? His music, his interview?
Yeah, I'm familiar with his music.
Have you ever heard him use the word slime, the term slime?
Yes.
Was that before you ever heard anyone say it, or was it after?
I hadn't heard it said before, but he's like one of the first artists I heard say it.
He being who?
Lil Wayne.
Okay. Your Honor, I don't have any other questions.
All right,